All right, let's get more information now from legal expert Dubazana Attorneys. As Nthabiseng Dubazana is joining us now just to tell us what she thought about the proceedings so far. Thank you very much, Advocate Dubazana, for your time. Just very quickly, first of all, as a layman, I'm trying to understand the technicalities that were argued by Advocate Billy Downer as prosecutor. He mentioned no application for condonation. My understanding of condonation in legal terms is an offence that is basically overlooked. Just explain to us what he meant by this. It was very technical for me.
Thank you for having me. So what was meant by Advocate Billy Downer was that in the application that the Zuma's legal team has launched in the Constitutional Court, in that after they had put in application that the court must instruct the president of the SCA, or at the time, to review her decision that there's no merit in removing Jacob Downer as lead prosecutor in this case. That decision came out on the 23rd of September, if I'm not mistaken, and that decision stated that the legal team for Jacob Zuma now has the right to appeal, should they wish, that SCA decision that was made at the time. Now, what Advocate Billy Downer is trying to say is that after that verdict came out from the court, it meant that the decision that was made in May of this year, that is where they should have applied for leave to appeal, which means the 15 days applicable in a normal leave to appeal situation would have kicked in May. So what Jacob Zuma's legal team is arguing is that we couldn't now say we're going to appeal 15 days after the May decision, whilst we were waiting for this decision that came out on the 23rd of September. Now that the decision came out on the 23rd of September, there's no need for us to apply for condonation, which means that condonation is saying to the court, listen, I know we're supposed to apply for leave to appeal within 15 days, and we missed it by this many months or this many days. And as a result, we're asking for the court to accept our apology for applying late. These are the reasons why we applied late. And as a result, if the court accepts this condonation, that the condonation application, therefore we can now proceed with the actual application of appeal. But Jacob Zuma's team is saying that they only could now apply for appeal once the court handed down their decision, which they did on the 23rd of September, and they are now within those 15 days whereby they can continue with a normal leave to appeal without adding an application for condonation.
And this has to do, of course, with the reconsideration, dismissal, appeal as well. So it's quite a lengthy case, this one. It's got application within application. But I want to talk about, his application even against journalist Karen Moore. I just wonder what you think legally, if the former president probably has any, leg to stand on. I'm playing devil's advocate here. We all know what the law says about, the POPI Act and not sharing very personal information belonging to someone, especially medical records and things like that. So when it comes to that, does he have a leg to stand on with that argument?
I think it would depend on if Jacob Mpofu is correct in his argument. So what he argued in the first appearance of the accused Karen Moore and Jacob Downer was that the application to remove this matter from the roll was being placed in the wrong court. So what he argues that the application to have the matter removed from Karen Moore should have been done within the criminal court. Instead, it is placed in the civil court under an urgent application. Now, it was supposed to have been heard on the same day that Billy Downer and Karen Moore appeared in court, but it didn't happen. The matter is now postponed to December, which now the issue of urgency now falls away. Remember, in terms of Rule 6 of the High Court, when we deal with an application on an urgent basis, it means that all the normal rules of the court fall away. All the times that we put, like your 15 days to respond and etc., fall away. These things are done within a period of about 7 days, so that this matter is heard with urgency. And if you're able to overcome the hurdle of urgency and convince the court that, yes, your matter was urgent, then you can now deal with the actual application as it is. So whether or not he has merit will depend on whether the civil court will agree with Nthabiseng Dubazana and say that they don't have jurisdiction to hear the matter. And if they agree with Nthabiseng Dubazana that they don't have jurisdiction to hear the matter, it falls away completely. So it's neither here nor there whether he has merit or not. The criminal trial will then proceed.